Okay, hello everyone. Welcome to today's webinar on young people in the law. My name is Ellen Limerick and I'm the Community Legal Education Officer here at Legal Aid. And sitting with me today is Raj Gill.
Morning everyone, thanks for joining us.
Thank you everyone. Raj is a senior lawyer from our Youth Legal Aid team. And you're acting principal lawyer for a bit.
Yes, I was acting principal for maybe about 5 or 6 months until earlier this year.
Yep, so you're hearing from someone very experienced and hopefully you'll all be able to learn something today.
All right.
Okay. So before we get into it, I'm going to go over some webinar housekeeping just in case there are people here who've not been to a Legal Aid webinar before. So this webinar is for community legal education purposes only. There's our disclaimer slide. All right, webinar housekeeping. So this webinar is being recorded and it will go up on our YouTube channel very soon. So I'll send an email around when that goes up there. Now, if you have any technical issues today, please call that number on the screen. And if you need any other information about Legal Aid's resources and publications or any future webinars, you can find it on our website. And it's on the Information for Community Workers and Carers page. Now, so we aim to do a 40-minute presentation and then leave 20 minutes for all your questions at the end. Some of you wrote fantastic questions already in your registration form, so we'll go through a few of those as well. Now, if you'd like to download these PowerPoint slides now, you can do so. You just need to click on the right-hand bar and go to handouts, and you'll see a PDF version of these PowerPoint slides there. So you can click on the link to download that. Now, if you have any questions throughout the webinar, please write them in the question box, and we will probably leave them to answer at the very end, but if they're pertinent to the current slide, then we will answer them as we go. All right, so we're going to start with a couple of polls. So now you know a bit about us, we'd like to find out some more about you. So can you let us know what area you work in? Do you work in Southeast Queensland, Far North Queensland, regional, or are you outside of Queensland? So we'll give you a couple of seconds to put in your responses. All right, I can see most of you have voted now, so I'm just going to close off that poll. Oh, a few more voting. All right, thank you. Okay, so you should see on the screen now that a large chunk of you are from Southeast Queensland. And then we've got some people from Far North Queensland, so 14%, and then 7% from regional Queensland. And no one's from another state, which is probably good, considering the content in this webinar. Okay. So I've got one more poll for now. So we just are interested in knowing how often you help young people who need advice about legal problems and in particular youth justice issues. Are you helping people every single day, or is it a sort of a rarer occurrence in your job? I know we've seen the list, and a lot of you work in youth agencies, which is great. We've got people from Headspace, Act for Kids, Life Without Barriers, Your Town, heaps of great organisations here. Okay, I'll give you a few more seconds to answer that poll. Okay, I'm just going to close off that poll now and share the results with you. Okay, so 11% of you deal with these issues on a daily basis, 26% weekly, 41% maybe once a month or so, and then 22% of you don't deal with them much. Okay. All right, so here's a bit of an outline of what we're going to talk about today. This was on the registration form, so you would have seen a bit about that. All right, and I think I'll just hand it over to Raj now to get straight into it.
Thanks, Ellen.
So, thank you.
All right, so thanks everyone for tuning in. In relation to today's purposes and what the content is focused on, it's in relation to children dealing with the police and the criminal justice system. So children referring to those 18 and below. So I'm aware that there are certain services out there that cater to kids or young people up until the age of 25, but for today's purposes, in terms of the information and content of the webinar, it'll be solely focused on children, so below 18, who are navigating through the criminal justice system, which broadly consists of, in Queensland, the courts, the police, youth justice, which is a government agency which assists young people that are having dealings with the law, breaking the law, and then lawyers. Obviously, there are other services on the periphery as well, such as child safety, youth and women, and other care organisations. So that's broadly what the focus will be on today. So in terms of practical tips, as you can see on the PowerPoint slide there's a dot point list about what some tips that I can provide in terms of a role of a support worker assisting a child who is dealing with the police and the criminal justice system. What I probably should emphasise is that obviously as a carer there's always going to be the desire to see the child or young person be held accountable and take responsibility for their actions, and sometimes it's the case where perhaps a carer would be wanting the child to be very frank with the police. But my, I guess, advice would be that the carer also needs to ensure that the child's legal rights are protected as well, and sometimes it may not necessarily be in the child's best interest to be so frank and forthcoming with police initially without getting some legal advice. And that's, so as you can see on the fourth dot point, it's very, very important that if you are assisting a child who's wanting to be spoken to by police, that you try and give our legal aid youth advice line a call.
And what's that number, Raj?
It's 1-800-LAQ, so it's 1-800-327-327. And we'll cover that a bit more, but just while we're on that topic, it's a youth advice line that's staffed by 2 lawyers from 8 a.m. to
we were
9
talking a bit about this before it started, and yeah, we really want to get the message out that call up that line if you have a young child, and you can call it as a support worker or community worker as well. It doesn't have to be the child that calls the line.
That's right, but in terms of if you are planning to call the line on behalf of the child, it's ideal that you have the child there with you so that we can obtain their consent and their authority for us to then discuss their issue with you. So I can't stress enough that please do, if you're unsure about anything that's police related or law related, and you're trying to help a young person out, please call the line. It's free. It's there, available from 8 to 9 Monday to Friday, and then 7 a.m. to 5 p.m. on a Saturday. So please do call that. One of the other ways in which I think a lot of our audience can assist young people being as a support role in police interviews, but it should be stressed that if you are not able to be impartial or objective, then it's probably not ideal to be a support person for that young person, and that probably would arise for a lot of you if there's a child that's perhaps committed an offence while in a residential placement and you're either the complainant or the witness. It's probably not ideal for that carer to be a support person when liaising with the police on behalf of the child. All right, so we might move on to the next slide. So, dealing with the police.
Sorry, did I skip 2 slides? There you go.
So I'm hoping to provide with this content just some basic points for everyone to be mindful about children and their rights with the police and how what their rights are in those interactions. As you can see, the police are able to conduct what often is called a street check if there's a child out and about on the streets at night time. It's mandatory for the child to provide their identifying details, so that's the name and address, and it's actually an offence if they don't do that, but they don't have to answer any further questions. A lot of the time we see that there are police that would photograph young people when conducting this street check. It's actually something that the young person doesn't have to agree to be photographed to. It's important to know that the right to silence applies. So that's going back to the point where I was saying that generally a lot of the people in a care role want young people to be accountable, want them to be upfront with the police, but they do have a right to silence, and that applies for criminal offences here in Queensland. And that's not something that if a child doesn't want to speak to police, it's not something that can be held against them. It's one of the fundamental rights. So that's something to be mindful about. And obviously, if the child or carer is unsure about any of these dealings with the police, again, the Youth Legal Advice Line is there to assist. So a lot of the time, the situations that commonly arise is that a young person is wanting to be, or police want to interview the young person, and that usually happens when an offence, police suspect that the young person has committed an offence. So again, going back to the previous slide, the young person can, if they do speak with the police, that anything that they say in a police interview can be used against them in terms of evidence. And so that's why the right to silence can sometimes be very important. And in that regard, police should delay questioning so that a young person can get some legal advice prior to speaking with the police. And if questioning can be delayed, as carers, what you should perhaps try and achieve or try and do would be to get that investigating officer's details, information, contact details, and then what can happen is you can call the Youth Legal Advice Line or any other lawyer really, but again, the Youth Advice Line does this quite regularly. Provide us with those details and we can have those discussions with the police to facilitate some or to liaise with them to see what their intentions are with the child and provide advice to the child moving forward. So we'll move on to the next one. So still on that same topic, if police can't delay the questioning, then the young person perhaps needs to decide there and then whether to do an interview with police. If they do commence the interview though, there's a part, or prior to any questions being asked, there's a process called offering a caution, which is basically, and you might probably have heard this in the movies, but police will say you've got the right to remain silent, you don't have to speak to us if you don't want to, you've got the right to telephone and speak to a parent, friend or lawyer. So if the interview commences and it gets to that point and you're there with the young person as a carer and support person, and the young person says, yeah, I want to speak to a lawyer. If it's during the hours of the Youth Advice Line, then the police generally will allow the child to give us a call, and then we can again speak to police, get some information from them, find out what their intentions are, and then speak to that young person and offer them advice. Again, in terms of the right to silence, like I said in the previous slide, a young person can politely decline to do an interview, not going to be held against them. It's one of their fundamental rights.
And what's the resource you put on the screen there, Raj?
So that resource there is a checklist for support people and carers to look at if they are wanting to be a support person during an interview. And that list is, or that link will take us, or take you through to the Youth Advocacy Centre website. So we work quite closely with the Youth Advocacy Centre. They're it's a great service for young people. They provide legal advice and representation, but they also provide some further holistic services such as support workers, youth workers, so on and so forth. So their website is very useful for a whole broad range of resources, but specifically they have a very helpful checklist for you as a carer or support person to have a look at to see whether you satisfy that criteria and can adequately act as a support person for a young person in an interview. So moving on from interviews with police, another common interaction that young people have with police is when police want to conduct a search of a young person. So I've got some points there.
Do you think this could be pertinent to people on the Gold Coast during Schoolies Week?
Definitely, definitely. So often during Schoolies, obviously there's a high police presence, obviously trying to make sure that people are behaving themselves and keeping the community and the kids safe. So a lot of the time they might encounter police in that particular scenario, and police may wish to conduct a search of the young person. So I've got a couple of points there that that are very important. That the search should always try and be conducted in the presence of a support person, unless, of course, the police are saying that if they delay it, then it would result in evidence being lost or destroyed. So that would usually happen if they suspect a young person, say, having stolen property on them or drugs. If they delay the questioning, delay the search, then perhaps then those drugs or the other items could be destroyed. So in that instance, the police would have the right to search the young person without a support person there. But obviously they've got to do that with in preserving and do that whilst preserving the young person's dignity. So they can't say get them to do a strip search in public. Not that I think that happens very often, but if it comes down to it, they've got to conduct themselves in a way that ensures that the young person's dignity is protected. All right, so I might move on to the next slide. And again, still on that same topic, the young person doesn't have to give police permission to search them. So what can happen in this instance is sometimes police are perhaps a bit too proactive and might just simply approach a young person and say, hey, look, we want to search you. At that point, the young person should probably ask them, well, what's the reason that you'd like to do a search? And if police aren't prepared to provide a vague reason or provide no reason at all, they should they've got the right to say that they do not consent to the search. But if the police continue to do that, then my advice would always be to be compliant and not obstruct the police, because any issues that come out of that search could be canvassed. If perhaps it ends up with them being charged, then they can get some legal advice from a lawyer to see whether or not that search was lawful, and that could be sort of canvassed through the criminal justice process. And then also that leads to the next point. If the search is conducted in an unfair manner, they can make a complaint about it as well. In some instances, police will say, and this is probably more relevant if they're entering a residence or something, police will say that they've got a warrant to search the premises or dwelling or house. If they do have that, then the young person or the occupant has a right to ask to have a look at that warrant to see if it's valid. Just moving on from, continuing on from that point, if police can still search a person if they don't have a warrant, and that's if only certain criteria are met. And I've provided a fairly exhaustive list there, which is in what's called the Police Powers and Responsibilities Act. It lists the reasons which the police must have before they decide to search any person. Doesn't matter if they're a young person or not. They need to satisfy those reasons before they start searching them. All right. So moving on from searches, sometimes property is taken as a result of conducting a search. So what you as carers can probably do in that situation is, I've got as one of the points there that if any property seized from the young person, try and get a property receipt from the police. They usually should provide that to you at the time. So as a carer and support person for a child, you should try and ensure that that happens. Sometimes things move fast. If you can't obtain the receipt there and then, it's probably helpful to make a bit of an itemized list about what items are taken and then follow that up with the police later on. If there's any issues surrounding all that, again, call the Youth Legal Advice line and we can see if we can assist with that. All right. So other types of ways in which young people often interact with police concern what is called a move-on direction. So if you read through that slide, it explains how that comes about. But in a nutshell, it's effectively if, for example, a young person is out at King George Square with a group, they're a bit rowdy, or they're fighting or conducting themselves in what police would deem to be in an unsavory way, they can then give a direction to move on. And if that direction is given, then it's the obligation of the young person to move on as soon as practicable. If they don't do that, or if they do that and then come back and the officer's still there, they can technically be charged with a criminal offence, which is more often than not what's called a contravene a direction or requirement of police. So that's something to keep in mind, that sometimes young people feel that they're a bit hard done by. If a police officer says, you know, get out of here and don't come back for X amount of hours, technically they've got to follow that, otherwise they could land themselves in a little bit more strife if they don't. Again, some further points about that. Obviously, police should explain why they're giving that direction. And as I said, the direction can be given for the young person to move away for a certain amount of hours, up to 24 hours. And then, as I said, it's an offence not to comply with that direction. All right, so this is when things get a little more serious in terms of young people and their dealings with the police. What if a young person is arrested? So if they're not arrested, they don't necessarily have to go with the police if the police request them, but obviously they can go voluntarily if a police officer requests them to. It's always good to ask the reasons for arrest, and police are obliged to give those reasons. Again, going back to a previous point where I was advising that it's always good to be cooperative and compliant. Same deal in this instance. It is advisable to maintain composure and be cooperative and compliant, because once again, if they're not, then there's a risk of further offences or a young person being charged with further offences, which is not something that we want to happen, of course. And if police do arrest a young person, they can be held for up to 8 hours for questioning, but the questioning can only occur for 4 out of the 8 hours. Again, the right to silence and other rights still applies. They don't have to participate in a recorded interview, but as if you as carers are present with them at the time, it's probably good to try and feel the police out about what their intentions are by asking them a number of questions, which I've got there in the third dot point. So you can ask them about whether the police will take any action, if they're willing to divert the matter, to youth justice for different outcomes, whether they're prepared to caution the young person or make a referral to either drug diversion or graffiti removal. While I guess I mentioned that diversion of the matter to youth justice, so diversion options are quite frequently utilised. So basically what that means is that if there's a young person that's being investigated for an offence and the police suspect that they have committed an offence and want to deal with them about that offence, they don't necessarily have to charge the young person. The Youth Justice Act, which is the law which governs children who are committing offences in Queensland, says that there are a number of what are called diversion options available, and that ranges from a caution being issued by the police, or a warning from the police, up into diversion to youth justice for the child to participate in what's called a restorative justice process, which is essentially a community conference where the young person, a support person, a lawyer as well, and you can contact Legal Aid about this, the victim of the crime or representative of the victim and Queensland Police Service sit around a table and discuss the offence with a view of the young person taking accountability for it. And so all of those options are available prior to the young person being charged and taken to court, which is essentially the last step. So that's something that is useful, and as a carer you should try and ascertain whether that option is available. But again, the youth advice line is available to try and discuss that with the police if you're not in a position to, or if the police are not being particularly cooperative or forthcoming to you as a carer. If you ask those questions, you can then ask them to, or call the legal advice line, and we can liaise with the police to get those details. All right, so I guess the last point there is something to note, that if the diversion options and the like are not considered by the police, then the next step would be for the police to then charge the child or the young person, and that might be through giving them what's called a notice to appear, which is a little slip of paper which says that what they've been charged with, and it'll have a court date on there. Or alternatively, sometimes what happens is that they have to sign what's called a bail undertaking, which is a promise to turn up to court on that first court date, and that might have some conditions attached to it, such as a curfew and the like, or worst case scenario, police can hold them in custody until they appear before a magistrate in court. All right. So this is probably a bit relevant to the time of the year that we're in, which is obviously schoolies. So there's some points there to note in relation to drugs and alcohol. There are a number of offences that can be related to alcohol and licensed venues. So possessing or drinking alcohol in public. So there's some places which I guess, for want of a better term, dry zones. It could be a offence to consume alcohol in that kind of place, giving alcohol to another minor, being in a licensed venue without a parent or responsible adult, and also using a fake ID or another person's ID to buy alcohol or enter a licensed venue. In terms of drugs, so all forms of dangerous drugs remain illegal in Queensland. So that is ranging from cannabis through to methamphetamines and the like. And associated offences can include possessing a dangerous drug, and that doesn't matter how small the amount, or even possessing pharmaceutical drugs. Certain pharmaceutical drugs without a valid prescription is also an offence. Something that I've, in my experience, seen that young people never seem to realise is that the offence of supplying dangerous drugs can even happen when someone tries to arrange supply of drugs to themselves. So it sounds a bit silly to a layperson, but technically in the law in Queensland as it currently stands, a person, including a young person, can be charged with supplying drugs to themselves. And then lastly, on that point, driving with any type of drug present in one's system is an offence as well. So again, when drugs and alcohol are a factor and a young person gets confronted by police because of this situation, police again have some search powers to search the young person or the young person's vehicle or their home for drugs if they suspect that the young person has drugs in their possession. And a lot of times police will say that that's satisfied by the fact that they say that they see the young person clearly affected by drugs or alcohol or smelling burnt cannabis and so on and so forth. And there's a few other points there to take into account when this situation arises. I've got there on the third point about items such as mobile phones can be seized as evidence. So that sometimes is quite common when young people are dealing with police and are caught up in drug matters. So going back to the previous point, as a carer, you should try and ensure that a field property receipt is retained. As you'll probably know, young people can't live without their phones these days. So if that happens and the phone gets seized, make sure that there's a field property receipt. Sometimes police then will search the phone, and if there's nothing on there of any particular note, then they can return the phone, so you should get it back, or the young person should get it back. Alternatively, they might seek to download the contents of the phone and then try and return it, or at that point they can perhaps return it back to the young person. So that's something that can arise on I guess a day-to-day practical terms. All right, so get on to the next topic, which is parties. Again, pretty relevant to this time of the year. There's some good resources out there, and we've got that on the PowerPoint slide where if a young person's having a party, it's always good to register that with police so they're aware of it, so that they can obviously prevent things from escalating. And there's also
so they can provide like police to come to the party to act as a security guard?
No, not quite. Not quite. So if you register the party on the Party Safe registration page, then my understanding is that the police will make note of that, and there might be a police car that drives by every so often during the evening just to monitor things, make sure things aren't out of control. And then obviously if things do get out of control, they'll know where to go and they'll get there pretty quickly. And that's why, going to that second point, it's very important to have some ground rules from the outset when having such events organised. All right. So things obviously have the potential to go wrong in these events, and when things go wrong, I've got there's some points there on the PowerPoint slide about what kind of things can arise in terms of illegal behaviour. So supplying minors with alcohol is an offence unless that supplier is a responsible adult for that minor, so a caregiver. Allowing minors to leave the party with alcohol. So going back to one of the previous points, consuming and possessing alcohol in some public places is an offence. An important one to note is allowing drugs to be consumed at the party venue is an offence. So that could also then result in the police rocking up and then doing a search of the venue. And then the last point is that if there's a guest at the party and they've requested to leave by the host has, I suppose, a ability to call the police if that person doesn't leave the house, and that person can be charged with trespass. So if a young person is at a party, they're told to leave, and they don't do so, then technically they could run the risk of the police rocking up and charging them with trespass or dealing with them for a trespass. So it's always good to keep that in mind. So again, parties can have the potential to go very pear-shaped, and that's when something is then declared for the purposes of the law an out-of-control event. So that is, as I've got there in the first point, an event. Out-of-control event is defined in the law as a gathering of no less than 12 people where at least 3 of those people are engaging in the following behaviour. And I've got that list there of what kind of behaviour can result in the out-of-control event being declared. So it's always good to keep that in mind and ensure that things like that don't happen. And obviously, it's good to nip these things in the bud. If it looks like things are getting pear-shaped, then it's probably a good idea to call it a night. So if things really do go pear-shaped, then, as I said, the police declare the party as an out-of-control event, and that can lead to a whole host of different legal ramifications. Persons who are organising the event can be charged with an offence of failing to take reasonable steps to not, that reasonable steps are not taken to avoid the party from becoming out of control. And parents can be charged as well as a result of that. There's some pretty stiff consequences as a result. Obviously, if you get charged, you may have to go to court, but then dealing with it through the court process can also result in police seeking that costs for the police response to that out of control event are paid by the people that are charged. And I've seen that through personal experience where someone's been charged with failing to take steps to avoid an event from becoming an out of control event. And the police have then, through the court process, sought for that person to pay for the costs of the police response. That ain't cheap. I can say that, that's for sure. So there's a few more points there. That's all right. All right. So appearing in court. So that's, I suppose, something that obviously happens when someone's charged. So this is, as I said previously, happens when the diversion options, cautions, and that sort of thing are either not preferred by the police or for any other reason not pursued by the police. Then the young person ends up being charged and being taken to court. So I've already discussed how they get to court on the previous slide, and I've got those dot points there. One thing I will expand on is that if they end up getting charged and not released to appear in court, then they're held. What will happen is that they're held in custody and to appear in court as soon as possible. So practically speaking, that would happen in the case where a young person gets charged with an offence, police say that the offence is either too serious or the young person's at risk of committing more offences. So what happens is that the police say they're not prepared to release the young person, and what will happen is that they hold that young person in custody to appear in a court, which is usually that same day, or if they're dealing with the young person in that overnight period, then it'll be the following day that they would then appear in court. Now, if that happens, there will be a duty lawyer available at the courthouse who will be able to assist the young person if there isn't any other alternative legal representation that has been organised. And then the duty lawyer or any lawyer appearing for the young person can then ask the magistrate to release the young person, and that's done by a bail application. So one thing for the audience to take note of is that it's very, very important that there is either a parent, guardian, carer or support person that is attending court in the event that the young person appears in court after being held in custody. So what happens if they're then charged and have to go to court? What can you guys do next to assist the young person? So legal representation is always the first start, or legal advice, I should say. That can be obtained privately. So if the child or carer or guardian or parent have the means to pay for a lawyer privately, they can arrange for that. or alternatively, Legal Aid Queensland can provide legal representation. And on this point, I should say that if for any child that is facing a charge before the court which is classified as an indictable offence, so that's an offence that's under what's called the criminal code, which is generally most of the offences in Queensland. So if they're below 18, charged with a criminal offence under the criminal code, then they automatically are eligible to receive legal aid funding. And I guess to put it simply, they get a free lawyer. Yeah. So there's some resources available on the Legal Aid website about how to arrange for that. Alternatively, you can call the youth advice line and we'll facilitate that on behalf of the young person as well. If you, for some reason, or the young person for some reason hasn't had the opportunity to arrange for legal representation and advice prior to the first court date, then at each children's court day, there is someone called a duty lawyer, which is a free legal service that's particularly in the southeast corner provided by Legal Aid Queensland, where we provide a lawyer at court on the day to provide advice and representation.
And anyone can get help from a duty lawyer, right?
In terms of children, yes, it doesn't matter in terms of whether it's a minor offence or a major offence. As long as they're below 18, they're a child, they're in court, then the duty lawyer is obliged to speak with them if the young person wants to have a chat to them. So the next slide here is about what can happen in court when the young person goes to court on that first day. So they could either, after getting legal advice, if they want to have their matter dealt with, it's generally through pleading guilty. The lawyer can advise about what the consequences will be if that happens. Alternatively, if they want to explore other options and get further legal advice or have a lawyer speak to the police on their behalf about any defences that they might have, then the matter could be adjourned to another day. So this is pretty important for our audience, supporting a young person in court. So a parent has an obligation to be at court under the relevant legislation, and a guardian or carer can suffice in some instances. So that would generally happen when we've got a young person in court who is perhaps under the care of child safety through a guardianship order. Then a child safety officer or a youth worker / carer can attend in place of a parent. And it's really important that they attend because the magistrate is unlikely to progress the case unless there is a parent, guardian, carer or support person at court. Now, one thing that I want to stress is that, and this is speaking from personal experience, we as lawyers can't speak to a carer or support person without the authority and consent of a young person. So it's a young person comes to court with their carer, they say they want to speak to a duty lawyer, the duty lawyer clarifies with them that whether they're happy for the carer to participate in the discussion with the lawyer, and they say no, they don't want the carer to be involved in that, then that's their right, because we act for the child. The child is the client, not the carer or parent. I'm not saying that to obviously sound critical in any ways, but that's just the role of the lawyer, that we act on behalf of the child only. But that doesn't mean that the carer or parent or similar can't weigh in. Obviously, we take that into account. But in saying that, our role is to act in the best interests of the child, and that often can sometimes, in terms of advocating for a specific result, that result sometimes is a little bit different to what some parents or carers are looking for the court to impose.
So you were saying before, parents might want discipline for the child,
that's
whereas
right.
that's not always in the best interest of the child in the eyes of the law.
That's right. Essentially, the court takes the approach that it's not, particularly in dealing with criminal matters, it's not there to be basically involved and impose orders for welfare reasons. It's there purely to punish the child adequately in proportion to whatever offence that they're charged with. So practically speaking, if a child goes to court for a minor offence of damaging some property. So maybe if there's a child in a residential care placement, throwing some plates and charged with property damage for damaging the plates. You know, a carer or similar might say, well, this child's been acting up, they need to be on a probation order to get them in line. That might not necessarily be appropriate in terms of when you look at that offence and the seriousness of it, which the courts in that instance would consider a pretty minor offence. So the court probably wouldn't want to impose a probation order, because it would be, if it did so, it would be doing so for welfare reasons, and that's not what the role of the court is in that particular circumstance. And so I think I've already covered this point. So obviously have a read of that on the PowerPoint, download that.
So go to the next slide.
I think we'll move on to the next slide.
We're running out of time. We want to answer your questions as well, so stay on for that.
So you've heard me go on about this youth legal advice line. So there's some information there about about its establishment. So it's staffed by youth legal aid lawyers, which are effectively specialist lawyers that only deal with juvenile crime. So there's 2 lawyers on from 8 a.m. to 9 p.m. Monday to Friday, and 7 a.m. to 9 p.m. on Saturdays. And we provide advice on criminal and traffic matters. But look, if you're not sure about something, still give the line a call. We can always try and point you guys or the young people in the right direction.
Yeah.
So there's some information about why the hotline was established.
Yeah.
And there's some statistics there about the purpose or the diversions. So I guess the main purpose of the hotline is to try and steer young people away from the court system if possible, because the statistics do show, and this is not the statistics on this particular slide, but the statistics show that if a young person's diverted away from the court system and has their matter dealt with through a diversion or a caution by police or a youth justice, restorative justice process, it's the statistics show that it's less likely for them to then go on to enter the court system. So that's what we try and facilitate.
Yep. Okay, so you've gone.
Yep, that's right.
I'm going to skip that one too.
Yeah, we can probably move on.
All right, as one poll here, we're just interested in whether you have used our hotline before, or if you maybe didn't know about it. If you've not heard of it before, you can type in a question saying that you've never heard of it before. Okay, I'll give you a couple more seconds to vote in the poll. Okay, I'll just close off that poll now. Okay, so the results are pretty interesting. So almost 3/4 of you say you've not used the phone line before, but a quarter of you say you have. All right. So Raj went over this information before, and you've gone through that.
Yeah, so this is just a summary of what kind of advice we can provide. But again, if you're not sure about something, just give us a call.
Yeah. Okay. There's some of our other phone lines too. We also have an Indigenous hotline, which is staffed by Indigenous First Nations people. So you can call that line to get some culturally appropriate legal information. These are our office locations. Many of you would know that. And here's also some other services that also work in this space, which might be able to help. So we've already spoken a bit about YAC and the great work they do. So that's their website there. And also Caxton and Logan YFS also have a lot of information. And there's also the Safer Schoolies website. So that's a Queensland government website, which has a small section on rights and responsibilities in the law and what young people can do over this period. All right, so any questions? So shoot your questions through, and we might stay another 5 minutes just if in case there's heaps of questions. So if you can stay on till about 5 past, that would be great. So we may go a little bit over time. Okay. So someone's asked here, in what circumstances might police not be able to delay an interview?
So that generally, I think, from my experience, happens when they are dealing with a child who they suspect has been involved in a very serious offence, and that would then result in them not being able to delay the interview. So what would happen is that they would arrest the child, have them in custody, and because it's a serious offence, then they wouldn't be able to say, well, you know, we'll do the interview at another time and release the child.
Yeah.
If that happens, then if you guys remember what I was discussing previously, the interview, if the child agrees to do the interview, then in the caution preamble, then you can utilise that opportunity to try and speak to a lawyer at that time, and then we can provide legal advice to the child. Other times, I suppose, when they can't delay the interview, can arise when they are trying to facilitate an interview with the child but then can't find a support person or parent. Then what can happen is that if the child wants to do an interview, then they would utilise the services of a justice of the peace. Yeah.
Okay, thanks, Raj. So somebody else has asked, what legal rights does a young person have if they don't speak English or have limited English? For example, when police approach them to do a street search.
That's, I suppose, I think in that instance, obviously, if the police are able to in my experience, if they are dealing with a young person who doesn't speak English in an interview format, then they can obviously arrange for a translator. But in terms of doing a street check, then I'm not entirely sure what the police resources are to try and facilitate a translator at that time. So unfortunately, I don't have can't provide an accurate answer for that.
It's a good question. We might get your details and get back to you. Okay. So if you've got any more questions, please put them through. Okay, so we've got another question. What happens if the seized phone has a password lock? Does the youth have to supply that, or do the police have some form to override the access the information on the phone?
That's a good question. So the police will generally, in that instance, ask the young person to unlock the phone. The young person doesn't have to oblige at that point. But then what would happen is the police would then seek what's called a court order, which then would require the young person to provide that access to the phone. And once that's obtained, then if the young person fails to supply that password, then they could technically be charged with committing an offence.
Okay. All right. Some more questions that you asked on the form. Okay, someone's asked, how do you explain a quite complex process to a first-time young offender who may be 10 to 12 years old?
So this is something that we do pretty often. So the main thing is just to really break the concepts down to the most basic level. So avoid using legal jargon, explanation of the role. There's a number of things that we generally ask the young person, firstly, to make sure that they understand the process. So I might say, well, I'm a lawyer, what do you think my role is? And what do you think the court's role is? So there's a lot of, in terms of trying to make sure that they understand, we'll ask them a lot of questions, we'll break things down to as simple as possible. If there's any concerns about them not understanding things, then we will take some further time to deal with the matter rather than just pushing it through court in that first instance.
Yeah, thank you. Somebody else has asked a question related to people with disability and if they're young. What other legislation or avenues can be utilised?
So I'm not sure if any of our audience is been paying attention, but the Human Rights Act is about to commence in Queensland.
Yeah, and we actually have an entire CLE webinar on the Human Rights Act, and it's up on it's about to go up on our YouTube channel.
So I think that Human Rights Act is likely to have a large impact, but unfortunately at this stage I'm yet to really familiarise myself with it. It's something that Legal Aid are rolling out through some CPD sessions for the lawyers here, but I suspect that the Human Rights Act will have some bearing on people or young people with disabilities navigating through the legal system. I guess another way in which the disabilities and interacts with the law is that depending on the type of disability, if it's something that's an intellectual disability, it can sometimes have a bearing on how the child's case progresses through the court process if they're going through court. And so sometimes the Mental Health Act applies, and we can perhaps try and have the charges dismissed or referred to the mental health court.
All right. So this is a question, I don't know if you know the answer to this one, Raj, but how does this affect those from New Zealand who have arrived after 2001? Is there any support?
I suspect that this is a question about whether or not there's any support for families with from New Zealand with children that are going through the legal system. So we don't differentiate if there's a child coming through the court process or the criminal justice process and their parents arrived in Australia pre-2000 or after 2000. We still would give them legal advice, and depending on what they're charged with, they're more than likely also still entitled to receive a grant of legal aid. So we don't differentiate in terms of their status if they're from a family that arrived here after 2001.
Somebody else has asked, when is it appropriate to call the police for young people in out-of-home care? So
I'm presuming by out-of-home care that is meaning residential care. All right, well, I'm going to get, I guess, with a bit of a personal view here. In terms of a lot of the work that we see, a lot of it is young people in care that get charged with offences which the courts and lawyers deem to be of fairly low level. And what we don't like to see is criminalisation of effectively what's bad behaviour. But obviously I am aware that carers and youth workers have their own protocol. So it's hard for me to provide advice when obviously the carer is the person on the ground at the coalface. They've got to make the call in line with obviously their employment obligations. But from my own personal standpoint as a lawyer, we certainly don't want to see a kid ending up in court charged with an offence just simply because they've thrown some tomato sauce on some walls in the placement. Because we've got to think about if that kid was living in a conventional family, would the parents call the police? So maybe this is something to take into account when making that call.
So someone else has asked, how do you provide a culturally safe service to Aboriginal and Torres Strait Islander young people and families?
Yes, just bear with me. I did write something about this when I was looking at the questions.
And if you've got any more questions, please type them in the box and we'll go through them as well.
So Legal Aid provide a lot of training opportunities to the staff here to try and learn some skills with dealing with Aboriginal and Torres Strait Islander clients. We've recently and currently rolling out some youth training for youth lawyers throughout the state, and quite a large component of that focuses on how to speak to Aboriginal and Torres Strait Islander children that are needing legal representation. And there's also been some continuing professional development sessions focused on that as well. But obviously, if a situation ever arises where there needs to be some perhaps further a need for further Indigenous specific legal services, then we wouldn't hesitate in referring that child to either ATSLs or any other similar Aboriginal and Torres Strait Islander legal services.
All right, so somebody else has also asked, who looks after the legal rights of children when in the child safety system, and child safety aren't maybe looking after those rights?
So this is, I think, a frustration that perhaps some of our audience have, and also we as lawyers have with the department sometimes. What I recommend is that if child safety are not, if there's a perception on behalf of the child or by the child that child safety aren't assisting them, then a referral should be made to the OPG, the Office of the Public Guardian, and their role is to advocate on behalf of the young person to the department and see that their rights and interests are being looked after. So I highly recommend you guys having a look at that resource, and it's pretty easily found.
They do a lot in the mental health space as well. So a lot of the questions people have asked are around mental health and the Mental Health Review Tribunal. So that might lead on to this question. Could you please address young people's rights in Mental Health Review Tribunal hearings?
So Legal Aid have a team that deal with Mental Health Review Tribunal hearings. It's not something that's dealt with within the Youth Legal Aid team, because we deal with criminal matters. So unfortunately, it's not something that I personally am well versed in. But let's just say someone contacts us and says, look, I've got a young person that I'm caring for that has a matter that's going through the MHRT. We can point you guys in the right direction, and representation can hopefully be secured through Legal Aid, Legal Aid's MHRT team.
Yeah. Is there any other questions you'd like to answer there?
Not unless you think there's something that's...
somebody's put in a question here about parties. So what happens if a teen is at a party where others are drinking or taking drugs, but they are not doing this? Could they still be charged?
Not likely, but sometimes what can happen is that there's police come to an address, they search it, there's drug paraphernalia or drugs sitting in the lounge room, and there's 5 kids sitting around there. Technically, if those 5 kids are aware of the drugs and the drug paraphernalia being there, then technically they can still be charged with joint possession. But more often than not, the police at that point would try and speak to the young person to try and ascertain whether or not they're owners of the property and that sort of thing. And if someone puts their hand up, says, look, that's mine and not, my friend over here, then it's unlikely that that friend would end up getting charged.
Okay, we might end with one last question, which is maybe a personal question, Raj. What's one very challenging or complex but overall successful case you've had that you're particularly proud of?
Well, this is a tough one. So I've been doing this type of work now for a long time, so I think it's a bit hard for me to think of a specific example, but I guess what I can say is that if we assist a young person and we never see them again, then that's probably a success, because the last thing we want are repeat customers coming through the court system. So I can't really at this point think of back to a specific example. There've been a lot, but not one that stands out. But generally, if we can help someone along through the system, get them the appropriate and best result in the circumstances, and we never see them again, then that's probably a success story as far as I'm concerned.
Yeah. All right. Well, thank you everyone so much for joining our webinar today. This is the last webinar we'll have for the year, so a bit of a momentous occasion for me, woohoo. But next year we'll have one in February, and it's going to be with Paul Holmes. A lot of you know him pretty well, and it will be around the buy now, pay later scheme, and how to help clients with that aspect. So the other thing I'd just like to say is that if you're not subscribed to our webinar program, please let me know. Send me an email and I can help you subscribe. So just email webinars@legalaid.qld.gov.au, because we run 10 to 12 webinars a year on different legal topics, and they might be very useful for you. So also, if you follow Legal Aid on social media, we always post updates about our webinars as well as other interesting news about what's going on at Legal Aid. So at the end of this webinar, you'll get a survey form. So if you could pretty please fill that out and let us know how we did, that would be fantastic. And after this webinar, we'll also send out the PowerPoint slides and also a copy of the YouTube recording of this webinar today, so you can refer back to it at a later date. So thank you so much for joining, and we'll see you at the next one.
Thanks everyone.
Thanks.
See ya.
Bye.